Mamuina Kwaba Adeba Odinho TV for one of the biggest financial loss to the state our Ghana mem has Dr. Kwabena Duffour versus the Accra High Court Mutrima almost Aqua Korea 5 million Ghana cedis enya asem ketwa train ensensem no estrani abasane city for sem no mokase die Dr. Krotinga Ayine attorney general kese pa etima because of such papa we emu 800 million 800,000 Ghana cedis abantinos or chemo senti sa papa we emfa no hodi na onko asika na akane die onfa andi native for na MB pamanuku no dwen ho a omonti asese adentina obi ababe wia wa punch 10 na wa re emu 6 na aka 4 na because of say 4 no abenti no sentino de aka ni na de and on fa na so on fa free ti for MPP man ko no dwen ho a monti asese e ba ne say na onipa yi akoko wia sika twetwe de na water free sika twetwe de of 5 million Ghana cedis and because of say or the 800,000 Ghana cedis abenti no musumu jano amana koneti for ko ne kutin sama moka and somebody to you madam
na anything entwe liquidity issues, insolvency, weak corporate governance, and we ko yisika every banker near buo money de kaka security officers e buo. Intisaria Bank of Ghana for step in say one omo hwehwe sa local banks iso no omo nhwe esu yi sika no omo de ye niam afoforo. Intisaria yenje management na anyede every omo za no be na Unibank March 2018, Bank of Ghana decided to take over the management of Unibank, citing says insolvency, inability to meet the financial obligations. Subsequently, in August 2018, and Unibank for a license, a free omonse, and consolidated and as well as UT, Bait Capital, some other banks, 4 banks, and now consolidated Bank of Ghana and now your friend is CBG. Now, almost as we are no file certain charges against shareholders, management of these various banks. They be Bait Capital and then Kwabena breakers and Dr. Duffour so almost file the same charges against it. But before then, Dr. Duffour a Ghana Bank of Ghana governor was also a former finance minister of the Republic of Ghana and also a Equatorial Bank. Unibank. Now, charges against Dr. Duffour the first one, willfully causing financial loss to the state. Allegations say actions by the directors and the shareholders lead to significant financial losses. Decisions be able to take care as directors of the various banks. Ama Ghana Bank of Ghana actually sika bebre. Enu be na calculate here do 5 billion Ghana cedis. Now, fraudulent breach of trust. Sika omusi omuni. No more chiro wo books mo se omuwo. Sene ya ebe painti picture say omu yeden omuni any form of liquidity challenges. And no charges are omudeba and money laundering. Instances of charges related to illicit financial transactions. And also eka charges are the state at the board Dr. Duffour then. And a contravention of Ghana Bank of Ghana Act. Bank of Ghana for breaches of banking regulations. The receiver sought to recover a substantial amount, reportedly over 5 billion Ghana cedis, from the defendant, alleging illegal transactions, unlawful loans, and acquisition of assets by related interest. Nyema omode masi won mo loans, won mo musika, won mo and may be related to the bank. What you say? Enfa the Bank of Ghana in Bra Omodiasi was a director central so enfa manage the banking affairs. Now, Dr. Duffour in turn, then at the case ne Eco PMO Supreme Court said almost challenge the suit against the state against Unibank and our normal directors. Case na ako aba and then you Attorney General say on Dr. Duffour Kotanasi. And on who say Dr. Duffour say obetima man 800 million Ghana cedis in landed property. Into Sadia we jai case no I in a civil case we James say Dr. Duffour and penny baby anything. Emfa into case no the state will not continue it again. And mighty minority, led by Honorable Asumedu and various members of parliament in the minority caucus, organize a press conference and the floor of parliament, chambers of parliament to say, so biaba be we our ponche among point washiro wa ponche be 6 now say odi 2 aba o say odi 2 aba intino 4 na mba en nkahwe nti enji 2 no ne ene yema ne nko ta ene wo Ghana embremu na sadia omo yede omo ma the attorney general some few days say once ne direction regarding Ministry of Justice then they will all interpreting the laws of this Republic of Ghana omo de we kwa PM Supreme Court. You go tie mighty minority press conference release here as against the statement of the Attorney General, the learned lawyer Ayine.
The court, I am told that they had called even the second prosecution witness. But today, the learned Attorney General tells us that on his own, he comes out and says that he negotiated with the parties without any court's involvement, and he intends to free. He has already entered a nolle prosequi, so he had freed them. The next question, or question 3, that I may want to ask. Transparency, as indicated in the press release, demands the learned Attorney General to explain to Ghanaians the principle of 60-40. Ladies and gentlemen of the press, once a nolle prosequi is entered by the Attorney General or the prosecution, we need not find out, and we don't need to find out questions. But he chooses to, if you read a press release, he chooses to justify why he had done that in the name of transparency. And that's why I say that transparency, as he had indicated in the press release, demands that he, the learned Attorney General, would explain to Ghanaians the principle of 60-40. If you're talking about 5.7 billion cedis and you tell us that you have retrieved 800,000 cedis, how can you say that that represents 60,000? And at any rate, is it a new policy directive, or when did this come into Ghana? When was this introduced into our criminal jurisprudence? What happens to the remaining 40%? To him, the Attorney General, today we heard him say that the 60-40, we can forget about the 40% because he uses the proverbial theft of sage goats, that if 2 or 4 are recovered, then he can allow the 2 to go off, meaning that the 40%, what the Attorney General in his jurisprudence is telling Ghanaians that he would let go the 40%. That means the 40% should go with. The press release makes reference to 60% recovery threshold as a benchmark for reconsidering prosecutions. When was this policy introduced and under what legal authority? Was this benchmark made public or debated in Parliament? Was it quietly introduced post-2024 to lower the standards of accountability? For a case involving 5.7 billion, can the Attorney General confirm that 1 billion has indeed been recovered and provide documented proof of the recovery? It is strange that the Attorney General is insisting that the amount of 800 million cedis recovered from